You're listening to the Subrogation Support Network, a podcast from Mattison, Wickert & Layer, America's subrogation law firm, with dissemination of new developments and changes in subrogation law, as well as emerging trends and best practices. Here's your host, Ashton Kirsch.
Hello, everybody. This is Ashton Kirsch, joining you today with the Subrogation Support Network podcast. Today, it is my pleasure to have my partner in our New Orleans, Louisiana office, Jim Buesen-Leonard, joining me today to talk about what I believe to be a fascinating and really developing topic, that being fraudulent check subrogation, and ultimately who's responsible for payment or reimbursement or making a demand on in those claims. Hey, Jim, how you doing?
Hey, Ashton, good morning.
Good morning. So Jim is a partner, been with the firm for a long time down in our New Orleans office. I am looking forward to coming down and visiting you sometime soon. It's gonna be a good time.
Mardi Gras will change you.
That's what I've been told. So to jump into the topic a little bit, Jim. Before we jump into the topic, why don't you tell me a little bit about you, your practice, and our office down in New Orleans?
Sure. The New Orleans office actually is the first branch office of MWL. We are going to have our 10-year anniversary coming up here in just about 2 weeks. So I have been practicing law for 30 years in both Louisiana and Texas primarily. I actually worked with MWL's managing partner, Gary Wickert, way back in the mid-90s in Houston with a firm there. And Gary went back up to Wisconsin, and I moved to New Orleans, and I was local counsel for MWL for a number of years until we started talking about opening up a branch office. So that's what we've done. And so I handle, we've got 2 associates here in New Orleans and a paralegal and legal secretary and myself. We handle all the Louisiana litigation, but we also handle subrogation and insurance coverage and insurance defense matters throughout the Gulf Coast area in general. We've got an office in Austin, we've got an office in Jacksonville, and we kind of handle the things in between.
Amazing. And yeah, it's exciting. 10 years. That's crazy. And ultimately, having an office down in New Orleans in Louisiana is a must and absolutely amazing, because sometimes the law down there, Jim, is confusing to say the least. It gets to be different down there, right?
Oh yeah, I've done whole seminars on the differences with Louisiana law. It's based on the Napoleonic Code. It's a civil code system, which is different than most of the rest of the United States. Is common law, which means you follow what the judges say. In the civilian system, you follow what a statute typically says. But before everybody starts having their eyes glazed over and switching us off, we will not be dealing with that today, because we are dealing with the UCC, the Universal Commercial Code, which has been adopted by most states, including Louisiana.
Absolutely. Yeah, we definitely don't need to get into that, but maybe one of these other days we can have that conversation on the intricacies and the unique nature of litigating in Louisiana. But enough of that. Let's jump into the topic at hand. So we're talking about paper checks, fraudulent check subrogation. Who's responsible? When I first started looking into this topic, I was thinking, when's the last time I actually wrote a paper check? And everything's all, electronic transfers at this point, be it from paychecks to, even paying a landscaper. And I just thought, it's like, I actually, the last time I wrote was a catering company, and they could only take checks. And I had to go dig through a dusty drawer and find my checkbook and, tear off a check and write it up. And it just reminds me, the world's changing a little bit. But ultimately, in the same way that the world's changing and we're seeing more electronic transfers, there's still a ton of checks, it's my understanding, being used by insurance carriers, small businesses, left and right. And with the advent and increase in technology, we're seeing a lot more room, the way I understand it, in thefts and in fraudulent activity involving those checks. In looking at, or actually Jim wrote an article on this recently, and he cites to check fraud actually nearly doubling between 2021 and 2022. It's a 23% increase. That was after a 23% increase between 2020 and 2021. And the issues in the post-COVID era, and even during the COVID era, we've seen just a huge influx in criminal, fraudulent activity, theft. Watch Bloomberg and watch any financial news, and you will see the retailers, small businesses going out of business, large retailers, publicly traded companies who are actually reporting huge impacts on their bottom line due to shrinkage or AKA theft. And it's really new because we have criminals. They're getting more brazen, more sophisticated. Technology's changing. Questionable economic times are really working together to create a perfect storm for theft and criminal activities. So I think that's why this topic is so relevant now, and why any adjuster, anyone working in the subrogation industry, attorney, adjuster, this is going to be more and more important as time goes on. So now, Jim, you recently handled a case you were telling me about where a check from a company to a vendor was quote unquote washed, and then the criminal cashed the check. What does washing a check refer to, and what does this mean?
Yeah, and just to go back for a second, talking about, you're right, there's still a lot of checks out there. Even though the average consumer like you and I don't write as many checks anymore, small businesses write a lot of checks. And criminals know that. And criminals also know that small businesses are sometimes not that sophisticated, so they target them. So what happened, in this particular case was it was a small business in Louisiana that was writing a check to a vendor, wrote it to the vendor's name, mailed it off. It was stolen. It was, criminals look and can see in the mail that an envelope looks like it has a check in it. They open it up, they take the check, they use technology to wash. And this is what check washing means. They take, it's the removal or erasing of the ink on the legitimate check and then rewriting and altering the check in some way, either by changing the amount of the payment or replacing the payee's name for their own benefit. So in this case that we dealt with, the criminal just changed the name from that vendor's name to his own personal name. And then he went and took that check in person to a bank in Delaware, walked in. It was about an $18,000 check, and presented it for payment. It was in his name. He had an ID, so the bank paid it. And then the bank sent it to the depositing bank, the bank that was for the small business, to have them honor it. And they did, because they're not the ones who were initially, being presented with the check. They're getting it from the depositing bank, and the depositing bank is warranting to them that it's a legitimate check. So they paid it.
Interesting. So now this actually kind of reminds me of Catch Me If You Can. You remember that movie where I think it was Matt Damon, whomever it was posing as a Pan Am Airway pilot, and he was marking off the checks in the bathtub and putting on new stickers and making new checks in a way. And why? And is that similar to what we're talking about here? Have things become more sophisticated? And what kind of technology are you seeing kind of being utilized to change or to wash these checks?
Yeah, so that it's similar. And you're right. I mean, the idea of just changing the name on a check has been around for a long time. And banks used to be able to catch that. Sometimes, a crude check with literally, whited over and something written over it. They can catch that a lot of times. But now with the advent of computers, it's become much more sophisticated. They can put it on a computer, take a picture of it, take off the name of the check on the computer, type in a new one, and print it out, and it looks like the same check in a lot of ways. Now, I haven't done this. I don't know exactly everything that goes into it. Let's just say, though, that with technology, it's become easier for anybody to do this.
All right. And to correct myself, it wasn't Matt Damon. It was Leonardo DiCaprio. Gotta love technology and Google, and then Tom Hanks. So interesting. So, all right. So now getting into subrogation, how does this wash check then turn into a viable subrogation claim?
Okay. So even though a small company may be vulnerable to this kind of theft, if they have a good insurance agent and they are well insured, they'll have a property policy that actually insures for theft and fraud. Same way that they would have insurance if somebody in their accounting department were stealing money from them and writing checks to themselves. That's the same, and another kind of fraud that is covered under these policies. So this check, when it was washed and stolen, when the company found out, and they found out quickly, this is going to be important. We're going to talk about this a little bit later about defenses to these claims and what companies can do to make sure that they can recover. They very quickly caught this. They reported it to the police, which you have to do. Most insurance policies, if they're going to cover it, a theft, you have to have reported to the police. They reported to the police. They also reported it to their bank and said, hey, wait, this is a fraudulent check. So the bank, and we'll get into this, the bank would not pay it, rejected the claim. So once that happened, then the company turned to their insurance company, who was our client, and said, okay, we want to be paid this now under the fraud coverage. So it was covered. The policy paid it, $18,000. They paid it, and then they sent it to MWL for subrogation and said, do we have any way of getting this money back from anybody?
Okay. No, and that's really interesting. So, I mean, it seems like there's quite a few lines of subrogation. So, I mean, it depends on where we have a lot of adjusters and attorneys that are probably listening in. And I just start thinking about, how interesting this is in that it sounds like, obviously fraudulent check is deposited. It's drawn from our insured's account. Our insured then makes a claim against the carrier, who assumptively in your situation here is your client or our client, at which point that insurance carrier then tries to subrogate for the amount paid, bringing a claim against the insured's bank, right? Because obviously they have that relationship, at which point maybe insured's bank pushes them back and says, no, go against the depositing bank, or they pay the claim or whatever happens, at which point then maybe the depositing bank, then, they end up paying it back through a subrogation or a claim by the insured's bank to that bank. And then that bank then maybe tenders it to their carrier, who then pursues the criminal. I mean, it's a whole line of parties here, which kind of makes things fascinating here. So there's a few different places where we could jump in as subrogation counsel. But my understanding is in the case that we're talking about, you were kind of the first in line, right? Where it was our insured, our client's insured, who was the one who had the check drawn on their account, correct?
Yeah. Yeah. And what you're describing is kind of like a insurance or corporate game of the ring around the rosy, when you're walking around the chairs and you don't want to be the last one to not have a chair. In this case, you don't want to be the one who has to go after the criminal. Because you're not going to get anything against the criminal. These criminals are too sophisticated, and even if you get something, you've got to go through restitution of the court. You want to get recovery from a party like a bank in this instance.
Right. And if we have time after this, I'll briefly touch on, for the audience, fidelity bond subrogation, something that I deal with quite a bit. And it's, relatively tangentially in a way related. But ultimately, right. I mean, it's going to be really hard to go against that criminal, that individual, if they can even be found, right? So we're trying to find viable avenues for recovery. Right. And it also reminds me of situations like commercial auto. Sometimes we'll get involved and, some trucking company down the line, right, where there's a broker who then subbed out the load, or contracted the load to a motor carrier, who then subbed it out to another motor carrier, who then brought in, their buddy Joe, who had a trucking company to actually ship this load. And next thing you know, we have a cargo claim or some other type of claim related to that carriage. And, we're pursuing down the line. I've actually had situations where I pursued the first in line by the shipper, that broker, who then has made payment, and then they retained us to go against the motor carrier, who then retained us to go against the next motor carrier. And it's a whole line. And it seems like, it could get complex in that regard. But I guess for our focus, we're looking right now against, we are insuring the company who had obviously the check drawn on their account. Okay.
Right. And so
Jim, go ahead.
Yeah. So when we got this claim in, the first thing we did was say, okay, so, where is the path of least resistance? Who's got the easiest, who we have the best chance of getting a subrogation recovery from here? And so we're looking at, you've got the depository bank where the criminal first went to cash it. And then you've got the drawee bank, which is the insured's bank, which, honors the check and pays it. Under the UCC, it's easier for the customer, or in our case, the subrogating insurer, to go against the drawee bank, or go against their own bank, than it is to go against the bank where the initial deposit was made. And that's because the claim against your bank, the drawee bank, is contractual in nature. The account holder, there's a relationship between the bank and the account holder that's contractual, and the bank's paying a charge based on a fraudulent check. When they do that, it violates that agreement, because they're only supposed to pay properly payable charges. So the question is, what is a properly, payable charge? But it's pretty obvious under the UCC, which most states, have adopted. There's a few different tweaks here and there, and that's why you really need counsel and subrogation counsel to delve into these states and make sure there's not a little change. But in most cases, properly payable just means that it was presented to them and was paid. And if it wasn't, properly payable, then if it was fraudulent in some way, it's not properly payable. So the good thing is when you're going against the drawee bank like this, you only have to show that it was a fraudulent check and they paid it. You don't have to show typically that they should have, caught it or, why didn't they catch it or anything like that? Because that's their first, reaction is these large banks. The reaction is, well, how could we have caught it? This is a very sophisticated criminal. They use this technology to wash this check. We couldn't catch it. This other bank didn't catch it. We couldn't catch it. We're not responsible. They are responsible under the UCC. They're responsible for paying back their customer because they paid a check which wasn't properly payable. And that's it, Ashton. I mean, they're done. There's no, as long as the customer followed just some really basic procedures to protect themselves. So, for example, the customer needs to, the company needs to, if they, had checks stolen and they didn't keep their checks in a safe place, or they've had checks stolen before, they didn't change the procedure, that might mean they wouldn't be able to recover. Or if they had several checks washed like this, and the first two, they happened several months ago, and they didn't do anything about it or they didn't catch it, and the third one then happened 6 months later, and they're trying to get a recovery on the third one, the bank is going to have a legitimate argument to say, well, no, you did not check your account record, you didn't, check your online or your account book and notice these before, so now you can't get recovery for this third one. But that usually doesn't happen. Usually what happens is these criminals just go against these banks, try to do this once. And if, most people are checking their accounts and, and catching these things. So as long as you catch it, you report it to the police and you report it to the bank, the drawee bank is supposed to be paying these claims. The more interesting question to me is why they're not, because they're not.
Right. And I think that the important for the audience to kind of catch on that, right, to synopsize it, is really that this is a UCC claim, right? It's a contract claim. So we're not looking at a negligence standard against the drawee bank, right? And that's why that's kind of the path of least resistance, the claim that we want to initiate with and start with if we are insuring, the individual who had that account where the fraudulent check was drawn from. So now back to mentioning, I mean, obviously the technology is kind of crazy out there, right? They're able to really wash these checks with great sophistication. How is a bank supposed to catch a fraudulent check in these scenarios?
Yeah. And so, I'm not a bank fraud expert. I'm sure that these large banks have all kinds of systems, to do that in some respects. But the problem is there's so many checks, running through their system. I mean, when we got involved in this particular case and made a claim against the bank reacted exactly like that. They're like, how can we do anything about that? We have millions of checks coming through a day. We can't, check all of them. And sometimes they're so, their washing job is so sophisticated that, and then they have no way of knowing that it was written to the wrong person. Every check, they're not going to call you up, Ashton, and say, did you write this check to somebody who was mowing your lawn? Or did you write this check to your cable company? Or whatever, there's obviously can't, follow up to that degree.
Right. So, and we briefly talked about the UCC and the legal basis, but is there anything else you'd want to add or that's interesting to you about the legal basis for the claim against the drawee bank's liability? Like any state variations or anything else? Or is this kind of, just based on, obviously most states have adopted the UCC, so we're applying and pursuing the same in a similar manner, the claim in a similar manner?
Yeah. No, only that, like I touched on before, the insured has to, or the customer has to show, that they exercise ordinary care and that, any failure, didn't substantially contribute to the alteration or the forgery of the check. So, as long as the customer, finds out about this and reports it as soon as they find out, and this is the first time, this has happened, then you're good. I mean, the UCC is pretty clear in that. The drawee bank, should be paying this claim, should be reimbursing their customer for this amount. And then the drawee bank can go against the depositing bank if they want to. And when they do, they might have a higher burden. They might have to show that that there was some negligence by the depository bank. And that's why you want to bring the claim this way. You want the drawee bank to have to worry about that. If you have to try to prove that a bank did something wrong or should have caught this, it's going to be very difficult.
So the depositing bank is ultimately also liable at some point, potentially. What about that depositing bank? When are they going to be liable? How do we see claims in that light?
Yeah, so I mean, there's more of a negligence standard, with that. The drawee bank, has a remedy against the financial institution that accepted the proceeds for deposit. Because the depository bank under the UCC warrants that the check's authentic and authorized and is free from any alterations. So that, allows the drawee bank to recover the loss it was forced to pay under the rationale that the depository bank was in the best position to avert the wrong and discover the fraud. And so typically that would be, when somebody like if the check is actually written in someone else's name and you've got a fake ID and you bring it in and use the fake ID to get the money, the bank, should be able to, catch that more often. That's the kind of thing they're used to seeing. That's what this is written for. It's more difficult, with technology and everything with a wash check is, how can the depository bank, even catch that? So the drawee bank may not be able to recover from the depository bank if there's, not something that they really, should have caught.
Right. And it seems pretty straightforward, right? We have the right in your place, at least with the exemplar case, to go against the drawee bank, right? And then they can then potentially, under a negligence standard, or also per the UCC, pursue that, the depositing bank. But if that's the case, why are the drawee banks, in your opinion, denying so many of these claims?
I think they have made, some banks, I'm not saying all, but the ones we've run into so far, I think have made a policy decision high up to deny these claims, even though they know that they're legally responsible for paying them and contractually responsible for paying them to their customers. They're denying the claims because they know that if they, just paid them easily or advertised the fact that, they were going to pay these claims and people were aware of that, they'd have so many claims submitted to them that they would have no recourse to recover from. So it's much easier for them, especially when we're talking small amounts, you're talking $5,000, $10,000. It's very easy for a large bank to say, well, no, we couldn't do anything about that. We're denying your reimbursement claim. You need to go after the depository bank. That's the one who's at fault. That's what they're doing. And when we pushed back on that and sent them, demand the law, we talked to their managers. We said, this is what the UCC says. They still outright denied it. So we had to file suit. They were forcing us to file suit, get it in the hands of a lawyer who then their defense counsel would tell them, no, you guys have to pay this. Even so, they're still fighting it. We actually had to file a motion for summary judgment on this issue, set it for hearing, and get within about 2 weeks of the hearing before the bank agreed to pay on the one claim that we've litigated so far.
Right. And it sounds like there's either one, these are purposeful actions to, obviously deny and refuse to negotiate legitimate claims. And also, I'm sure there's an aspect of this is that there is some complexity here. And ultimately, I know that in speaking with other attorneys outside of our firm that don't necessarily deal with subrogation or financial instruments, and talking about fidelity bonds or fraudulent checks, I mean, it's a unique area that really you need to have a level of expertise in to truly grasp how this process works, given applicability of the UCC and kind of the general idea that most attorneys, most adjusters, they kind of think of that mindset of negligence standards. And if there's ever kind of strict liability on product cases, maybe that's when it comes into play. But we don't really deal with the UCC as often when it comes to pursuing recovery or subrogation. Would you agree with that?
Yeah, but Ashton, the reason why I think, at least in this case of this one particular bank, that they're doing it on purpose is because I had another claim. So, we talked about the earlier claim with the company paying their vendor, and they and we ended up settling that claim after we had to file a motion for summary judgment. In that, when I spoke to a claims manager and his assistant and, educated them about all this, they still wouldn't pay. They finally paid when we had that motion pending. I then get a second claim against the same bank from a completely different party, somebody who was a client of ours, came to us. In this case, it was an individual. It's not an insurance company. An individual who had paid property taxes on one of his investment properties by writing a check to the local sheriff and putting it into the mailbox. the mailbox was robbed and all the checks were stolen out of it because somebody knew that everybody was writing large property tax checks that day. And this was a check for about $8,000 or so. Took it, did a pretty crude washing of the check, actually. I mean, you can tell that somebody has kind of done something to, I don't know if they actually just covered up in some sort of white ink or something, like whiteout, like we, used to do in the dinosaur days. But it was kind of crude, and they just wrote in their own name and they cashed the check. And then it got back to our client's bank was the same bank I dealt with before, and they again refused to pay it. I actually contacted the exact same claims manager I dealt with on the other file and said, hey, I've got another one. It was just like that last one that we ended up settling. How about we settle this one instead of my having to file a suit and file a motion like last time? And he gave me the exact same line he'd given before. No, we're denying it, and you need to go against the depository bank. So to me, he's reading from some corporate playbook that has been given to him.
So this is purposeful. Wow. Yeah. And then maybe we can talk about how future actions will be. But before we go into that, I'm curious. What are the legitimate reasons, right? If they are going to deny, if the drawing bank is going to deny this claim, what kind of legitimate reasons, basis could they have to do so?
Yeah, really the only one whatsoever, legally at least. We know what the reasons are from a commercial perspective. They're just afraid to start paying these claims or to pay them easily because they cannot catch these things. They do not have they've probably not put the resources. They probably have to spend a lot of money to protect their customers and catch these claims, these fraudulent checks. So instead of doing that, putting all their money into protecting their customers, they're putting money into denying these claims outright. But the only legitimate reason they would have is the defenses we touched on earlier, where the customer, the account holder, was negligent themselves. Didn't protect their checks. This has happened before. They didn't report it for too long. Also, most of these contracts require you to report it to the bank within a year. So if this happened more than a year ago, the bank doesn't have to pay it. You've also got, of course, statute of limitations in many places that would also restrict your ability to sue over this, for breach of contract at some point. So that's it. Those are really the only reasons that they would have to deny it.
And it sounds like in your cases, these aren't even the reasons that they brought up, which is kind of unique, right? They're just throwing out some, hey, somebody else is responsible. You should go against them, right? Rather than even raising or even providing any evidence that they have a reasonable basis, such as lack of notice or, as we discussed, failure for the insured, our insured here to take reasonable steps to counteract.
Right. And that's because in my demands, I was very specific and I've gotten all this information from our clients already. I gave them the documents showing that, what had happened and the fact that they had checked their account records, within 30 days and caught it and reported to the police. And they had reported to the bank and provided all this stuff to the bank already. They were well documented. So they could not argue that our client had committed any negligence on it.
Which is I discuss in most of these podcasts, whenever we talk about investigating or things that adjusters can do. This would be a prime example of where quick action, educating our insureds on what to do is really going to play a huge factor here. Because once we get that information, you were able to go into that, do some basic investigation, which I'm sure is absolutely necessary on these, and, inquire into, did the insured do everything by the books? Did they do it right? Is there something missing? Because I'm sure we need to know that, right? That's just integral in our being able to pursue and understand these claims.
Right. The last thing you want is to file a suit on one of these things, go into some discovery, fight for 6 months on it, and then find out that this is the third time that a check has been washed in exactly the same manner from this, from the same customer, and that they had ignored it before or hadn't caught it or somebody they knew or something like that.
And now these banks, they have a duty to their clients, right? To our insureds here to pay viable claims and to make payment and to actually negotiate appropriately per their duties under the UCC. And to me, from what you're telling me now, it sounds like they are just purposefully reneging or negating that duty and refusing to even play ball when they know, or they should know, that they have an obligation to their customer. That's wild to me. I mean, this sounds like something that's be it a class action or some sort of mass tort or some major case that's just waiting to happen. Would you agree with that?
Oh yeah, and they're very sophisticated in the way they wear down their customers. Because what happens is, as a customer, when you make a claim to your bank to be reimbursed for a stolen check or fraudulent check like this, the first thing that happens is they ignore you for a while. They'll send you a document. They'll respond and they'll send you a document to fill out, and you fill out with the information. But then all of a sudden, you're dealing with some person in a call center, in another country that at different hours, or that's difficult to talk to, or they don't get back to you, and then finally, after in these cases, the bank took like 6 months to get back to the customer until they just tersely deny the claim. So they really try to wear you down and say, well, they want people to say, well, it's not worth fighting over a few $1,000s.
And I'd imagine that quite often that customer is going to their bank, the drawee bank first, right? Before even tendering it to their insurance carrier to say, hey, you guys owe this, and they're denying it. Then we get it. Then we make the claim on behalf of the carrier. Frankly, the adjuster probably also worked it up a little bit, and they're still maintaining that line in the sand that, hey, we're not responsible. Go against the depositing bank.
Yes, that's exactly what's happening.
I'd imagine that there's just a huge amount of these claims outstanding, right? A lot of the people listening right now, and a lot of our clients, they write small business policies, commercial policies for businesses that are totally, I mean, we probably have a ton of unidentified subrogation involving these claims, right? So we need to encourage the listeners, our clients, to kind of start thinking in this way and to keep this in the back of their mind, where it's not necessarily that we always need to prove that depositing bank was negligent, which is oftentimes what we need to look at with surety bond subrogation and fidelity bond subrogation. But in this situation, there's really a strong cause of action and a strong claim that can be made that can even justify pursuit of smaller cases. I mean, it's not like these are big banks or even small banks, right, that are definitely collectible, right? So we need to be finding ways to appropriately identify these claims and make sure that we get them with counsel. Do we have any advice for the listeners on what the adjuster should be doing to help identify these claims? And then once they've been identified, make sure that they appropriately pursue these cases?
Yeah. So I think you're right, Ashton. The natural reaction of a subrogation adjuster who hasn't dealt with a lot of these claims would be to say, well, gee, this was theft, fraud. We're not going to get anything from the criminal. So, there's no subrogation potential. They need to, think, outside the box a little bit. And in terms of, if there was a bank involved in the theft in this way, and, do they have a claim against the bank? They probably do. And then they need to immediately get with their customer and make sure that their customer has gone through all the procedures that they needed to do so the customer wasn't negligent. They need to make sure that it's been reported to the police and that you get the banking records from the customer to see that this hasn't happened, hasn't happened before, and that everything is fairly, recent. And a copy of the check is obviously, very important, so you can see exactly how it was altered. But then, once you do that, it's really not that much. It's less documents and investigation than you need for a property subrogation car wreck kind of file.
Right. And it sounds like in your experience, these banks aren't just making payment, right? So our clients are going to have to, or adjusters are going to have to realize that these probably aren't cases where you're going to send demands for 2 years and then eventually get payments, right? Which frankly, I don't recommend at all, right? Send a few demands, 1 or 2, and then get it to counsel if you're going to push forward or close the case. But this sounds like there's just very little chance that, with further pushing, those banks are just going to make payment to the insurance carrier. And that those adjusters, they're going to have to realize, hey, when this happens, we should just get counsel involved. Determine whether it's viable to pursue. I think you'd agree with that. And then associated with that question is, is there kind of like a dollar value that we think, it's going to be worth litigating? Because, typically, our firm, we're very reasonable to our clients. We don't do dollar value thresholds, anything like that. But obviously, a smaller case against, a $5,000 case against the depositing bank, that may be really difficult because we're going to have to prove negligence, and we have a much higher burden of proof there, or prove that obviously a more higher standard under UCC. With these, it seems pretty straightforward. Are we able to pursue smaller dollar value cases for clients on cases like this, or is it more viable for them to think that litigation could be feasible?
Yeah, so we're absolutely able to pursue smaller ones. There is, a line where it's not, economical for the client to pursue. But, I brought one that was $18,000 and I got back $15,000 on it. And we probably spent $400 on filing suit and serving that one. So it was a good, good recovery. I've got one right now that I've sued over $8,000. It's the same thing. So, but at some point, if you're going to spend, $400 or $500 filing the suit, and then if you have to file a motion for summary judgment and you're charged based on, all your exhibits that you have to attach, including the insurance policy, and so you might have another $1,000. I've seen court costs of $1,000 in filing an extensive motion before of all the exhibits. Then you're talking $1,500 and you're trying to recover $3,000 or $2,000. That doesn't make a lot of sense. So, probably something above, $5,000, most of the time. Now you can cut your costs by filing in courts that are of different jurisdictions, lower jurisdictional amounts, your city courts, justices of the peace. There's pretty much any jurisdiction has layers where you can have a smaller dollar amount and file suit, and the court costs might be less. The other costs might be less. The problem with doing that, though, in these kind of cases, and that, I've avoided that. I usually file suit in district court with a judge who's a lawyer who's been either appointed or elected, as opposed to, say, a city court or justice of the peace court, where if it's a lawyer, it may not be a lawyer at all who's the judge or the justice of the peace. And if it is, then they may not have the kind of background where they are going to be interested in trying to grasp the UCC. What we're talking about is not super complicated, but most people are not familiar with it unless they have a banking background. And so a judge in a district court is probably going to spend more time and read the law on it and side with you, as opposed to maybe a justice of the peace who might just say, well, what could the bank have done about it?
Right. I mean, it's similar to what we see for all of us. We see arbitration is a problem, right? With a lot of times where I deal with a lot of cargo claims in strict liability cases, where I have to go and I write, help the client write the contentions. And next thing you know, we're saying, hey, negligence has nothing to do with this. There's no burden of proof on me to prove that there was a duty and duty was violated or anything involving negligence. It's strict liability, or in this case, it's UCC, right? It's a contract issue. At which point you then get a summary, opinion coming back saying you didn't prove negligence, you lose, right? So, I mean, that's the hard part about when you have, those individuals who don't necessarily understand the differences here, which hopefully all of our audience now does. So if there is anybody who's on any panels or with any of the arbitration companies, now you know. But it's important to keep in mind, I agree with that recommendation that, when you're dealing with UCC other items, it may be really hard to put this before a small claims court, justice of the peace, or anything like that.
Yeah. Yeah. And you bring up an interesting point with arbitration too, because some of these claims that we're talking about may be subject to arbitration. The contract between the policyholder and the bank may call for arbitration sometimes. And, it's difficult to know that because it's not like that's something you have ready access to sometimes. You might have to do some digging to actually find a copy of the contract with your bank, for that kind of thing. But some of these things may be subject to arbitration.
Excellent. Now, Jim, as we wrap up that conversation, obviously on the fraudulent checks, any other comments or any other things that you want to mention to the audience?
No, except, these are, this is another just great example of the world of subrogation is very, very diverse. And don't just assume that you don't have a claim, as ridiculous as it might sound. In terms of recovery, don't assume that you don't have something. And here's a good example of a situation where immediate reaction might just be, well, we can't go after the thief, so that's it. But you've got a really great contractual claim against a bank that you wouldn't have known about if you hadn't listened to this podcast.
Absolutely. And I'd encourage all adjusters, everyone, all attorneys, anyone with insurance companies to start thinking about this a little bit further. Look at their files, maybe even do a closed file review, see what you can find out there, because I can guarantee you there's a lot of missed subrogation opportunities out here involving this exact issue. And if there's questions, if there's any concerns, Jim is an expert in this issue, in this area. I'm sure he'd be happy to speak with you, to just have a quick phone call, review an email, take a look at a case if anything comes up. Jim, can you confirm your email address and how people can find you?
Yeah, It's J Busenlener. So it's JB as in boy, USENLENER at MWL-LAW.com. And of course, on our website, MWO-LAW.com is everybody's got their information there as well.
Perfect. And now we have a few more minutes. So I wanted to very briefly just give an intro to another topic that is very related, just because I want to make sure that the adjusters and those listening don't necessarily confuse fraudulent check claims and what we're talking about with fidelity bond subrogation. You all right, sticking around for a few seconds so we can have that conversation?
Yeah, sounds good.
Beautiful. Now fidelity bond claims, they're different. And we're going to do a whole podcast on this within the next few weeks. So this is kind of a teaser on that issue. But what a fidelity bond is, it's a bond, or there's related insurance coverages that carriers write that cover their employee theft or fraudulent activities for those that are covered under that policy. So a lot of times that's management, employees of the insurance company. A lot of claims we see here that are paid under this coverage or under this bond would be those involving fraudulent credit card usage, right? Where, I go out and I use the firm card to go buy a bunch of baseball cards, right? For my personal use or whatever it could be. Or other situations we see in that all the time now with obviously the advent of, electronic payments is we'll see an assistant to the accounting manager or somebody along those lines go to a customer and say, hey, we've changed our procedures. We want you to send payment to this account rather than this account. And then they're directing that payment into their own personal account. We also see quite a bit of check washing in this regard, where the employee is getting a hold of those checks and they're washing it, changing the name into their own name. Other situations we see with this would be just simply depositing checks in the company name at another location, right? Where that, be it the assistant to the accounting manager, goes to the local check cashing company. They go to the counter with a check from, ABC Railroad to, Joe Schmo Plumbing Company, at which point they then just give them the check and they don't really take a look. They deposit it. They steal the funds. So these are different claims. This isn't a claim in most scenarios involving the UCC. It is a negligence standard typically. But a lot of times we have the right to, there's kind of three ways that these cases go. One would be there's an obvious action by that insurance carrier for the employer to go against the thief directly. So that would be just a civil action against that individual for the theft. Oftentimes also these, quote unquote, these criminals, these employees that stole, they're tried criminally, right? So there's the right to seek restitution. Now, we do have an arrangement with some clients where we do help them with those cases, though, we are a civil litigation firm, so we're not really in the business of going against uninsured third parties. So we are really focusing when we get those cases on taking a look, finding the diamond in the rough. And it's really maybe 1 out of every 5 to 10 cases where we take a look and we say, hold up, this isn't just the employee who's responsible. There's a third party that we can go after, right? And third parties could be, one, I've pursued a ton of cases against the check cashing company, be it a bank, a business. I know that a lot of big retailers and businesses are now depositing checks. Or it could be where the claim is against them for their failure to identify a fraudulent check, for their negligence in not asking for an ID identification, and so forth. Other claims that we have would be like we said, against a bank, oftentimes against credit card companies for not flagging these transactions. The credit card company ones can get more interesting because ultimately there's a lot of other recourse per the consumer agreement with that credit card company on what is actually going to be charged back to the customer and what the credit card company, kind of bear the risk of. And also against, we've also brought cases against the vendors even, right? A vendor or a customer where they didn't, they've had a process in place for years. Always the check goes to this individual, or always the bank that they are paying to through electronic transfer is this bank. And the next thing you know, someone they've never spoken to reaches out and says, hey, write the $500,000 check to this account. And then they do it, right? So there's claims in that regard too. I just want to toss that out there. We'll have a whole conversation in a few weeks about fidelity bond subrogation and these types of claims. But I just think it's important to note and briefly outline because, I don't want anyone kind of confusing the two, right? These are two different coverages. These are two different types of claims. And the claims that Jim had discussed at the beginning, they are significantly, just in general, more collectible, right? We're always going against typically a collectible bank, going against the Draw E Bank, And I mean, I think that it's just important to keep these things in mind. Right, Jim?
Yeah, although, I would say that there is some overlap though, because in your situation with the Fidelity bond, if there has been a fraudulently altered check that the drawee bank paid, and the Fidelity bond, ends up, that insurance ends up paying on it, they could go against the drawee bank on a fraudulent check under the UCC and get repayment reimbursement in the same way we've been talking about today. It's just that a Fidelity bond example has many other kinds of ways that they would have to be paid that may not involve a fraudulent check per se. And these UCC remedies that we've talked about only apply to fraudulently altered checks.
Correct. Absolutely. So we still have the same rights when it is a fraudulently altered check to go against the drawee bank in the Fidelity bond context. But there are just many, many other additional parties that come into play in scenarios that kind of go beyond that.
Right.
Excellent. Well, Jim, thank you so much for joining me today. This is a fascinating topic. Audience, thank you guys so much for coming on, listening to this podcast. It's always a pleasure. If you have questions, Jim and I are both always available to have conversations, answer questions, review claims, whatever you need. Again, thank you so much, Jim. It was a pleasure.
Thank you, Ashton.
All right. So signing off from this episode of the Subrogation Support Network podcast, this is Ashton Kirsch. Until next time.